Hi, everyone. Thank you for joining us. I am Juan Herrera, Vice President of Dispute Resolution Programs here at BBB National Programs. I help lead programs like BBB AUTO LINE, which handles lemon law and warranty claims, as well as class actions and some exciting new programs in California based on recent changes to the state's civil procedure laws. I am really excited about today's conversation because I get to speak with someone I've known for a long time, Colin Rule. I first met Colin back in the early 2000s, and we reconnected in 2017 when he visited our headquarters in Arlington, Virginia. Over the years, I followed his work closely. In fact, some of what he's written has directly inspired how we've used our technology in our programs. Colin is the president and CEO of ODR.com, and he's known as one of the pioneers in the field of online dispute resolution, or ODR. He's also worked at eBay and PayPal, where he built systems that helped resolve millions of disputes. Let's start with the basics. Colin, not everyone in our audience might be familiar with ODR. Could you please explain what it is and why it's important today?
Absolutely. Thank you so much, Juan. It's great to be here with you, and I'm really excited about our conversation. So online dispute resolution refers to the use of technology. And we talk about technology, we talk about information and communications technology to help people resolve their disputes. And that was pretty much the definition that we came up with back when I first met you, 20 years ago, because there wasn't really a lot of technology in the dispute resolution process. But what's happened since then is now we have a wide variety of technologies that are relevant to dispute resolution. Not only video conferencing technologies like Zoom and Teams, but also artificial intelligence and other ways that we can assist parties. So a lot of people think, when they think technology in dispute resolution, they think about the internet, which is a very, very powerful communications technology. But other technologies that we overlook are also very powerful, like the telephone. And whenever they invent new technologies, we are the first in line. I remember when the iPhone first came out, I thought, this is going to be really good for resolving disputes. So really, if you know about ADR, alternative dispute resolution, which is usually face-to-face, ODR is the same thing as ADR. It's just ADR accelerated by technology. So that's fundamentally what it is.
Absolutely, Colin. And I remember you worked at eBay and PayPal back in the day, which had massive volume of cases. If you don't mind me ask, how many disputes were you handling at the time, and how did those systems manage that kind of scale?
It's a great question. When I left eBay in 2011, we were resolving 60 million disputes per year, which is more than the U.S. civil court system at the time. Now, I imagine, I'm not affiliated with eBay anymore, but I bet they're probably doing about twice as many of those disputes now. And I imagine Amazon is doing 3 times as many as eBay. And Alibaba in China is probably doing 3 times more than Amazon. So we're talking about more than 1 billion disputes per year that are taking place between buyers and sellers. So we only had 25,000 employees at eBay when I first started there. So there was no way we could manually work those disputes. So we had to create software to enable the parties to resolve the disputes themselves. And that was really the origin of online dispute resolution, was figuring out how to handle these cross-border, high-volume, low-value disputes.
And I'm sure handling that many disputes is no small task. What did you learn from those experiences? You kind of mentioned that just now, but especially when you're looking at keeping things efficient and fair for both sides.
Right. Well, and again, I had been a face-to-face mediator and been in the dispute resolution field for 10 or 15 years prior to starting at eBay. So I was well versed in sort of the ethical guardrails of dispute resolution practice and dispute systems design. But I learned a lot at eBay, because we were kind of figuring out a lot of things for the first time. eBay kind of invented e-commerce to a certain extent. We were the first online e-commerce marketplace. And so we built what was called, at the time, it was the first resolution center. When we first launched it, we called it the disputes console. And people didn't like that. They didn't like the word dispute. So we turned it into the resolution center. Essentially, it was the same thing. So any user had access to a console, a page that listed all of the problems that they'd encountered in transactions. And they could go and click into them and, track every case all the way to resolution. And we built specific pathways to different types of resolutions. So if it was a payment dispute, say a seller listed an item on the site and the buyer they won the item, but they didn't follow through and pay. That was a very different resolution pathway than, say, if they bought an item and they paid and then it never showed up, which is what we called an item not received dispute. Or they bought an item and it showed up and it was different than what they expected. So we called that as a SNAD dispute, significantly not as described. So, I actually have here on my wall of my office a picture of Frank Sander, who's one of the fathers of the dispute resolution field. And Frank Sander, he came up with a concept called the multi-door courthouse, which said instead of having just one way of resolving cases, you should have a table out in front of the courthouse with a friendly person. And every time someone comes up, the person at the table says, "Hello, welcome to the courthouse. What kind of dispute do you have?" And they say, "Well, I have a family dispute." "Okay, you go through door number 3. That's a special process that's built just for you and family disputes." And the next person comes up. "Oh, okay, I have an IP dispute." "Okay, you go through door number 7. So that was a pretty radical concept when Frank first hatched that back in the 1970s. And really, that's what I saw us doing at eBay. We were building a multi-door courthouse with different pathways to resolution for the different main dispute types that we encountered. And because we saw hundreds of millions of disputes over the time that I was at eBay, we got really good at predicting what the best pathway to resolution was for each different type of issue that arose.
Yeah, and that balance, between fairness and speed is something that we also care deeply about here at, BBB National Programs. Now, let's bring this into a more current context, if you will. A big part of our work here at BBB National Programs is making sure that consumers have access to fair and efficient ways to resolve disputes, as we were just talking about. As especially in the areas of automobile, which is one of our larger areas, and also where things can get a bit complicated. You're looking at time and a lot of emotions involved. And so, from your perspective, Colin, what tools or steps are most important in helping consumers through those kinds of challenges in a way that feels, again, fair for everyone involved?
Well, it's a great question, Juan. And one of the other things that Frank Sander was famous for saying is fit the forum to the fuss. So you have to build a dispute resolution process that meets the needs of the disputants in that particular kind of case. Now, our average dispute at eBay was about $75 for an item not as described case. An automotive purchase is a very different ball of wax. I mean, you're talking about $10,000, $20,000, $30,000. You couldn't take a dispute resolution process designed for an e-commerce purchase where you're buying a book or a shirt or a CD and then just say, okay, well, now this is going to apply to this $20,000 automotive purchase. Because as you say, it's complicated. There's a lot of things that can go wrong in a car. Whereas a DVD, either it plays or it doesn't play, or, either it's the right movie or the wrong movie. So we had to build specific dispute resolution processes for automotive transactions. Now, the way that I created a framework for online dispute resolution when I was at eBay, thinking about how to design these systems. And I called it the DNMEA framework. And it's almost like a staircase. So D stands for diagnosis. N stands for negotiation, where two parties just talk with each other to try and work it out. Mediation is M. That stands for assisted negotiation. And then there's evaluation, where somebody comes in and they render a decision. And then the last A is for appeal. And that was kind of the way that we thought about it at eBay. The goal was to get as fast a resolution as possible. If you could prevent a dispute from arising, that's the best way to resolve it. But if a dispute does arise, the first phase is diagnosis. And sometimes you can go diagnose the problem, and then the complainant gets their concerns addressed, and they don't even need to contact the respondent. But fundamentally, we had a problem-solution matching algorithm where a complainant can come in and say, this is the problem I have, and here's the evidence that I have that problem. And then we would say, okay, here are common solutions to that problem. Which of these solutions would you be willing to accept? And they say, well, I'd take A, I'd take C, and I'd take F. And they can customize it too. Maybe they want a partial refund, or maybe they want a replacement item, something like that. And then we can go to the respondent and say, hey, look, your consumer, this person, had this issue with this purchase on this date. Here's the evidence of the problem that they described. And here are the solutions that they're willing to accept. Would any of these work for you? And, if the respondent said, yeah, I'll take solution A, great, you've got a resolution. But if not, maybe you need to go back and forth and facilitate a conversation between the two of them. I think the key thing is you don't want it to be party A versus party B. You want to have both sides aligned, focused on solving the problem.
But let me shift a little bit into, before and after pandemic, right? Because there has been A lot of dispute resolution happened in the past in person, at least for us in Autoline, where, we had to have meetings where arbitrators would meet up with the participants, and it had to be done in person. But overnight, it felt like, things, we had to adapt, we had to change, and we had to pivot. Where were you when COVID hit, and how did you see the field change?
Well, it's a great question, Juan. And I remember exactly when it happened. I think it was at the beginning of 2020. And I had really just taken on a new role as CEO of mediate.com, which is one of the biggest websites for mediators. And we did a lot of training and a lot of standard setting around the practice of mediation. And then boom, this pandemic hit. I mean, I had heroes of mine, and I was long known as kind of the dispute resolution nerd. I love technology, and I was urging people to try more technology in their mediation practice. And I had heroes of mine who were legendary mediators who had told me for years, you can't do this online. You have to do it face to face. You've got to be in the room with the parties. You have to see the tapping foot. You have to smell the pheromones. You just can't, the magic won't work. But then the pandemic hit. And a lot of mediators were like, wow, what are we going to do? How can we practice? We can't get together face to face. So we were the leader in rolling out trainings on how to do Zoom, how to move your practice online. What are some of the security concerns? Because obviously as a mediator, the confidentiality of the process is primary for any dispute resolution process. And we did trainings and we did standard setting and all of those things. And now, amazingly, after the pandemic, it's not gone back to the way it was. Our studies indicate that more than 80% of mediations happening in the United States are happening now over video.
No doubt, Colin. Lots of improvements came out of that shift. Now, if I was to ask, what challenges still remained, if you were to give me a couple of challenges, top of your head.
Sure. Well, I mean, obviously, not enough people know about or utilize dispute resolution. So the perennial challenge we have in the field is spreading the word. I think a lot of people, when they encounter a problem, they immediately think of the courts. Like, I need to get a lawyer, I need to sue. I think there's something that we call litigation romanticism. There's so many TV shows about Law and Order or Boston Legal or LA Law or Ally McBeal. I mean, just people get a constant drumbeat through the media about the law. And we don't have any good TV shows about mediation, sadly. There've been a couple tries, but it's not as dramatic, I think, as, Law and Order catching the bad guys. So what I find, and I've done lots of small claims mediations in courthouses, is parties will come in thinking that it's going to be like an episode of Law and Order, and I kind of have to set them straight. Let me tell you what really happens in small claims court. This is not going to be a 2-day trial. You're not going to be calling witnesses. So part of the challenge that we have at mediate.com is trying to educate people about the availability of these great programs to help them find resolutions and also to assist them in their negotiation, because some people come in with a very fixed pie orientation. It's like, well, every dollar I get is a dollar the other side doesn't get. So I'm just going to bully them. I'm going to threaten them because that's the way that I get more value. And, as we know, people who do this professionally, it's much more interesting to be in a value creation, integrative mindset. It's like, okay, well, how can we figure out a way to solve this problem together to maximize our gains on both sides, which requires a little more creativity and less of a, me versus you orientation. But I do think we're doing a good job. I mean, from when I first got trained in mediation in the late 80s to now, the culture has really evolved, and there's much more of an understanding of the value of direct communication, negotiation, win-win outcomes. Those things are part of the zeitgeist, but Absolutely. We have a lot more work to do.
Yeah, and I agree with you, and that was a great way to put it. Those TV shows. That is absolutely correct. Part of the culture, I guess. But let me ask you a question here in terms of, or maybe make a statement. At BBB National Programs, we started using some helpful AI tools where our infancy, I will admit, things like, real-time transcripts and sentiment analysis, to support our team and improve the experience for consumers and manufacturers. It's been useful for quality control and understanding where things might need attention. There's a lot of talk right now about how AI could change the way we handle disputes. Do you see, Colin, that AI will be a big part of the solution, or maybe it may make a statement? At BBB National Programs, we started using some helpful AI tools where, our infancy, I will admit, it has been useful for quality control and understanding where things might need attention. There's a lot of talk right now about how AI could change the way we handle disputes. will play a big role in the future of DR?
Absolutely. Absolutely. I think when you look back from 2 or 3 decades from now, back on this time, I think the arrival of COVID-19 in 2020 will seem less of a world-changing event than the launch of ChatGPT 3.5. I think that will, in retrospect, will seem like, whoa, this is like the invention of the printing press, because what we've seen is AI has completely transformed the way our society works. Everyone is using AI in medicine, in finance, in entertainment, in law. And, we don't even know where it's going to go, because these algorithms are going to become more and more powerful over time as they absorb more information and computer processors become more powerful. So there are lots and lots of ways that AI is poised to both increase access to justice and improve the efficiency and effectiveness of dispute resolution. As you say, one of the things LLMs, large language models like ChatGPT and Gemini and Claude, one of the things they're very good at today is summarizing information. And, as a human, if you get a complicated case with 100 documents in it, well, that may take you hours to go through those documents and read them all and absorb all the information in there. And it's very difficult for you to retain all that information in your brain after you've done it. Well, an AI, you can provide 100 documents to an AI, and it can read it and provide excellent summaries with all the key issues in minutes. And if you have any questions over the course of the dispute, you can ask the AI, and it will find every occurrence. It doesn't forget anything. So the wave one of AI coming in and assisting dispute resolution is in that part of it, absorbing complex information. You also talked about sentiment analysis, and that's also something AI is pretty good at. If a user or a complainant comes in and they describe their dispute, AI can do a good job sort of reading, how distressed are they about this, and maybe summarizing and triaging, and maybe even doing a little reframing for them to say, okay, from what you said, it sounds like your dispute is this. And it may pose it back to them in a way that is more resolvable than the way that they originally expressed it. So those are the things that LLMs can do today. But there's a lot of things that LLM is going to be able to do tomorrow, and we're starting to see glimmers of that. I see in some of the mediations that we support, parties are now coming into mediation with printouts from ChatGPT, saying, okay, well, the mechanic did this to my car, and now I have this issue, and I had to go pay to get it. What would be a fair resolution? Because I think a lot of people, when they go into a dispute resolution process, they just want a fair outcome. They want to know that they're not being taken advantage of. And it's very interesting that an LLM like ChatGPT or Gemini or Claude, if you give it all the details in the prompt, it will give you an estimation of what it thinks a fair resolution is. And sometimes that's a big obstacle in dispute resolution, is the parties don't know what their case is worth. Is this worth $100 or is it $1,000 or $10,000? And a lot of the debate is in that fog, where people don't really know what the case is worth. But if you have a third-party resource like an AI that can provide that, it can really help you find what we call the ZOPA, the zone of potential agreement. So there are many other ways that AI is poised to evolve and improve the effectiveness of dispute resolution, but those are some examples.
Yeah, quite remarkable with a lot of that advancement, Colin. And here at BBB AUTO LINE, we place high volume on human judgment. It's at the heart of how we ensure fairness. But at the same time, we're always looking for ways to improve efficiency and support the people doing the work. What might a hybrid model look like? One that AI works alongside the people to strengthen the process? Do you think AI can help mediators and arbitrators more effective, whether through better insights, time savings, and strong case management, as you were just outlining?
Yeah, so we have a key concept in the online dispute resolution field, and it's called the fourth party. So the father of online dispute resolution was a professor at UMass Amherst, a guy named Ethan Katch, and he wrote a book called Online Dispute Resolution with his co-author, Janet Rifkin, back in 2001. And in that book, he introduced the idea of the fourth party. So if you think about party one and party two, those are the disputants, right? The complainant and the respondent. Party three is the human neutral. And that could be a mediator, that could be an arbitrator, that could be a coach, that could be an ombuds. There's a wide variety of different roles the third party can play. But technology, Ethan argued, is the fourth party. And the fourth party has a seat at the table. Now, there's a lot of things that we ask the fourth party to do today. Like it processes our payments, it schedules our meetings, it manages all of our documents, it sends out notifications. All of those things are sort of table stakes now. It doesn't sound like science fiction at all for the fourth party to play those roles. And few of us would go back to a time when we had to do that manually, on the phone and sending out documents. I mean, that was rough. It took a lot of time and energy to do that. But now we give it to the fourth party, and then we can focus on the human aspects. Well, now AI is poised to make the fourth party even more effective. And it can do some of the things that only humans could do before. But it was very time consuming for humans, as I say, to review all the documents, or to generate a draft settlement or evaluate the appropriate outcome for a case. So what's going to happen is we have to partner with the fourth party. And the fourth party is not going to replace us. Much like what happened with the rise of Zoom or the rise of the internet or even the rise of word processing. There were things that humans manually had to do before, and then technology came in, and then technology took it over. But the humans still remain the boss of the process. And that's what I always say in my trainings. I say the third party is in charge. The third party is running the mediation. The fourth party is an eager assistant that is there 24/7 and works for pennies. And there are some things that the fourth party can do that the third party can't really do or shouldn't do. But we have to learn how to partner between the third party and the fourth party. I often say mediators are not going to be replaced by AI, but mediators with AI are going to take work away from mediators without AI. Because, and now I'm part of a group at the National Center for State Courts talking about the impact of AI on the legal system and the judiciary. 6 months ago, the conversation was, is it ethical for lawyers to use AI to work with their parties? And there was a lot of conversation about that. Now, 6 months later, the conversation is it ethical for lawyers not to use AI? Because if there's something that would take you 10 hours, and those are billable hours, but if you used AI, it would take you 1 hour, is it ethical to charge the parties the 10 hours if you could get it done in 1 hour with AI? So that's where I see all of this is going. Humans aren't going to be replaced. AI is going to make us actually more human because we're going to focus on the parts of the dispute that only humans can handle. And then we'll shift all of the administrative stuff over to the AI.
Yeah, no, that sounds like it's already happening, Colin. And kind of reminds me of, this smart contract, right? There's a lot of buzz around them. Are they useful yet for consumers' transactions, like, buying cars or handling the warranty?
Yeah, smart contracts are very interesting. If you were to have asked me before the pandemic, which is going to be a bigger deal in 10 years? Smart contracts, blockchain, AI, or virtual reality, I would have had a very hard time answering because all three of them were kind of going strong at the time. But now we know the answer. Now we know AI is a much bigger deal than the other two. But that doesn't mean that virtual reality and smart contracts don't have value. And a lot of the work that's happened, maybe it's slowed down, through the last couple of years, but I don't think it's going away. So when you think about virtual currencies, like Bitcoin and Ethereum and all the transactions, there's been a lot of things that have been built to create a virtual finance system, a virtual banking system. But a lot of those technologies, including blockchain, which was originally created for Bitcoin, which creates an unalterable ledger in the cloud where you can put something into blockchain that can never be changed. So that's a really important trust technology. And those of us in the dispute resolution side have looked at that and said, wow, that could be really powerful for dispute resolution as well. If you and I agree to engage in a transaction and we create a smart contract, which isn't really like a paper contract that we sign with ink on the bottom, it's more a little computer program that we both have vetted. And then we say, yep, this looks good. And we both e-sign it. And then we put it in the blockchain. Well, now that can't be altered. So 4 or 5 years down the road, when we may have a dispute, we can go back and look at that blockchain smart contract and see what was it that we agreed to. And the other thing that's great about smart contracts is they can be self-executing. So there could be a flag that says, if I build you a website and if that website gets 1 million visitors in a 1 month period, you're going to pay me an extra $100,000. Well, the smart contract is in the cloud. It's watching all the time the traffic on the website. And if ever that flag is tripped, you get 1 million visitors in 1 month, then I automatically get the payment of $100,000. So you don't have to worry about a file drawer full of paper contracts that you have to memorize and go through and check and see, hey, am I in compliance with this? These are self-executing. They live in the cloud and they can't be altered. So the question is, how can we use that trust technology, which was created for virtual currencies like Bitcoin, how can we use that in the dispute resolution context to provide instant redress to consumers? And I think that's a very exciting question. Now, a lot of the smart contracts that are out there are very simple. If I say to my cryptocurrency exchange, if the price of Ethereum crosses $10,000 a coin, then buy me 5 coins. That's a very simple smart contract, and it's self-executing. But if you say to someone, okay, we're going to have a smart contract that says if the transmission on my new Chrysler goes out within 3 months, I'm going to get an automatic reimbursement of X amount of money. Well, how does the smart contract know the data about the performance of your car? So you have to build something called an oracle that gives the visibility to the smart contract, the information necessary for it to self-automate. So there's still some key pieces of technology we have to put in place in order for smart contracts to realize their full potential. But it seems to me inevitable that that's where things are going. And just like we're getting rid of paper currency and we're moving towards digital currency, we're going to be getting rid of paper contracts and moving towards digital contracts. And once the contracts are in the cloud as smart contracts and they're unalterable, I think it opens up huge new possibilities for transparency, fairness, justice, and rapid resolution.
Yeah, and with all these AI tools, Colin, what rules should be in place to make sure everything is fair, transparent, and trustworthy?
Yeah, we're spending a lot of time thinking about that. Now, there's an organization called ICODR, ICODR.org. That stands for the International Council for Online Dispute Resolution. And it's a spin out of the National Center for Technology and Dispute Resolution, also at UMass Amherst, where Ethan Katch was a professor. And ICODR has a set of standards for the use of technology in dispute resolution. So you can go check them out for free. They're translated into 16 different languages, and it calls out a lot about some of the concerns about AI. On the one hand, AI is a very powerful tool that can expand access to justice and improve transparency, but it also could be abused, right? You could have somebody create an AI and they put their thumb on the scale, so it's biased towards one side or the other. Or it makes representations about the process that aren't accurate in terms of who has access to what. It's not hard to imagine an online kangaroo court that utilizes some of this technology in a way that obfuscates the unfairness to one party or the other. So that's why at ICODR, we have these standards, and we do monitoring of ODR platforms to ensure that they operate within the ethical guardrails that we've established. And one of the things we have in dispute resolution is great ethical guidelines for mediators and arbitrators and dispute resolvers. But we don't have a lot of ethical guidelines for coders, people who are writing the software and training these AIs. And you can insert bias into a dispute resolution process as a coder if you put in rules that, again, put your thumb on the scale. So that's one of the things that we're going to have to get better at as we have more technology in dispute resolution. Just like we monitor the ethics of mediators and arbitrators, we need to monitor the ethics of the software platforms that are being used. And I do think over time, we're going to weed out the bad actors and find trusted software platforms that everybody acknowledges through transparency, don't have a thumb on the scale. But that's one of the things we all need to work on together as AI becomes more prominent.
Absolutely. And that is fascinating. I'm glad that you're there, Colin, to help out with that.
Well, I'm a nerd, so I love this stuff.
Yeah. And you mentioned, just briefly as a personal note, you mentioned that you are also near the autonomous cars. Have you had a chance to drive one yet? Or
Well, you don't drive it, right? You ride in it. Yeah, I have. I've been in a couple of Waymos in San Francisco, and the first time you do it, it's a profoundly unnerving experience to get in, and it just takes off, goes off into traffic, But they have a big screen that shows what the car sees, and it's amazing. It sees everything. I mean, it can see every pedestrian, every obstacle, every light pole, and they know the data has shown that self-driving cars are safer than the human-driven Ubers and Lyfts, So that's why it's going to take over everything. And, we're at the beginning of this, but maybe in 20 years, the human-driven car will be the exception rather than the rule. But I had a friend who got into a Waymo, and it was a very foggy day in San Francisco, and the windows were fogged up. So she couldn't see anything. But the car just took off and drove into traffic. I mean, you can't see anything around you. You don't see the other cars, but it can see because it's using radar. So it's kind of weird to be in a car where you can't see anything around you and it's weaving in and out of traffic and turning right and turning left. But they are designing now self-driving cars that in the back seat, instead of having 4 normal seats like a sedan, maybe it has a yoga mat, or it has a desk. So you could do work because you don't have to pay any attention. You don't really need a driver's seat. The car does that itself. So you could just, so it's going to change a lot.
I'm not sure how bad traffic is in San Francisco. I imagine it's not an easy thing, but if you get the chance to do your work too while you're on one of those cars.
Absolutely. Even better, right? You can play a game of Monopoly while you're driving to the concert, so.
Yeah. Well, that's great, Colin. This has been a really fantastic conversation. I really appreciate you taking the time to share your thoughts, your experience, and vision with us. And I cannot thank you enough.
Well, Juan, thank you so much for having me. I'm a huge fan of the work that you're doing, and I really enjoyed this conversation, and brainstorming with you is a real privilege. So thank you.
Likewise, Colin. And thank you for my audience for joining us, and thank you everyone for watching. We're excited to keep building the future of fair and accessible DR, dispute resolution. Thank you.